Welcome to In the Name of the Law with your host, Liisa Speaker from Speaker Law Firm. Joining her today is Steve Sinas from Sinas Dramis Law Firm, along with Mary Chartier and Takura Nyamfukudza from Chartier Nyamfukudza PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. In today's episode, we're going to talk about a new approach to family law mediation, using genealogy to solve crime, and bicyclists having accidents with motor vehicles. Stay tuned.
In the name of criminal defense.
Internet sites that allow people to submit their DNA are widely popular because it allows people to connect with relatives. But now these and other genealogy sites are being used by law enforcement to pursue crimes. So we're here today to talk about this issue with Mary Chartier and Takura Nyamfukudza of the Chartier Nyamfukudza Law Firm. And we want to talk about the genealogy sites used in crime investigations and privacy issues that go along with it. So let's begin by addressing why are law enforcement doing this and what authority are they relying on to conduct these types of genealogical DNA searches?
Well, it's fascinating because this is a huge untapped resource for law enforcement that they have now at their fingerprints. So people are willingly uploading their DNA, and there are over 100 billion people who've put their DNA online in a database. And they're doing it for a couple of reasons. They want to find out what their background is. So, for example, they can check on their ethnicity, but they also can connect with relatives. My brother has actually done that and found relatives from our family small town in Italy, in Australia, and all over the world. But law enforcement realizes that this is an amazing network of DNA, and they are trying to use this to solve crimes. And some resources, they are able to use without getting a warrant, and then for others, they are being required to get a warrant by the company. But there's a fascinating case out of Nebraska that Takura and I have followed where this young man, decades ago, killed his parents. He was convicted. He was in prison. And then he and another person broke out of prison. And they ultimately made their way to Chicago. The other young man was caught, but this gentleman never was. And for decades, nobody could find him, but the police were really just focused on it. And it passed from detective to detective to detective until finally a detective said, I'm going to take a look and see if I get a hit in the database online, one of these genealogy sites. And they did. They found the man's son. The man had been living in Australia for decades. He'd had a family. By what everybody says, he was a great dad, great community member, great neighbor. No one knew he'd been convicted of these two murders here in the United States. He had passed away a few years ago, but they ultimately knew what happened to him, and they unfortunately had to break the news to his son that his dad had been a convicted murderer. But the dad did tell his son that he had been an orphan, which is why he had never met his grandparents, which I guess technically is true, although he killed his parents, and that's why he was an orphan.
So is the tactic that the law enforcement is using, is that reserved for the most severe cases like the murder case you described?
No, it's not, Lisa. While the most famous success story for law enforcement would be the Golden State killer who terrorized the California area in the late 70s into the early 80s by raping and killing people. Those are not the only types of cases that it's used in. For example, we have cases where law enforcement don't always know who it is that they're searching for, and they don't always have a warrant. For example, we have very recent cases where a newborn child's DNA was used to ultimately convict her father of a sexual misconduct case from decades prior. Additionally, property crimes. Police have taken the DNA from criminal sexual conduct victims and used their DNA to investigate property crimes. So no, it's not limited to those cases.
And let's talk about the genealogy sites. Do they all protect privacy in the same way, or are there different rules that apply?
Unfortunately not. Some sites, though, some of these commercial sites do require law enforcement to bring them search warrants, and others just kind of give it up to folks. And what's clear, though, is that when law enforcement use their databases, there are rules that protect suspects and everyone else. But those same rules do not apply to these commercial sites. And the fix is for legislators to make it absolutely clear what the strictures are, and there have to be real consequences with actual teeth for breaking these rules.
What's interesting, though, is even if, so I'm not a part of those genealogy websites, are you?
No.
Yeah, right. So
Me neither.
I know, so none of us, right? So our DNA is not up there, but my brother's is. So if there's a company that allows the government to search voluntarily with no warrant, then they get a hit on my brother, then that will lead them to say, okay, well, this crime was committed in this state. So, does he have any sisters who've traveled to that state? And probably it would be pretty easy to figure out which one of my brother's sisters maybe traveled to a particular state, since we all live in different states. So it's really fascinating that while someone might be really private and not upload their own DNA voluntarily, if they've got family members, cousins, aunts, uncles, siblings, children, it's still accessible to law enforcement, either voluntarily by the company or with a warrant.
So have law enforcement ever nabbed the wrong person because they're relying on this genealogical website information?
They did. There's a case out of New Orleans where they actually grabbed a documentary filmmaker who's now making a documentary about being nabbed as the wrong person. I think they found another family member's DNA on the website. And unfortunately for the filmmaker, he had been in the state where this murder was committed, and so they thought it was the wrong person. DNA has all kinds of issues with it. I mean, we've challenged some DNA testing and been successful. A lot of people think DNA is the gold standard, and it may be in comparison to other types of forensics, but certainly it's not infallible. In a very large number of cases, you can challenge it, but this is an example of how it is fallible because the wrong person was targeted.
So what are the justifications for using these genealogical sites when there's so many privacy violations involved with the investigation on that front?
Well, a lot of companies think that what they are doing is beneficial to the community. So, and that's a pretty common theme with a lot of people. They'll say, well, if you don't have anything to hide, why do you want the police to have a warrant, whether to get your DNA or to search your home or anything, right? But the Constitution is the one that affords that privacy right to individuals, at least as it involves your home, now your vehicle, which they didn't have cars when the Constitution was, drafted. But it is a privacy interest that people have. And so some companies really believe that they're being good citizens and good community members by opening up their database to law enforcement to just comb through. But I guarantee for most people submitting their DNA, they've got no idea that at least some companies are voluntarily opening it up to law enforcement.
Has the privacy issue been litigated in courts?
It has, Lisa, but at least in Michigan, not in our appellate courts or at the United States Supreme Court level yet. And of course, for trial courts, that's where they would have precedential value, meaning lower courts would have to follow it. So not yet. Stay tuned, though.
Okay. And have other DNA-related issues been litigated in court?
Oh, sure. Yeah, I mean, DNA-related issues, everything from the privacy aspect of it to actually how the testing is conducted. I mean, what's really interesting here is as technology advances, and it seems to advance at lightning speed, the courts need to keep up. And I think we covered in another one of the shows the geofence warrant, which allows the police to essentially look at a particular time. So if they know that a crime was committed on the corner of, Main and First Street at midnight, they can get all of the cell phones that were in that vicinity, and then that's how they start narrowing down their suspect list. There are people who don't have a problem with that, who essentially say they're an open book. Other people, like myself, and Takura and you, we've got a big problem with that. And as you know, we talk about all these issues on our podcast, constitutional defenders and more.
Fascinating. Thank you.
Thank you.
In the Name of Criminal Defense is brought to you by Chartier Nyamfukudza, PLC. In the Name of Family Law.
Welcome to our family law segment. Today we're going to talk about mediation in family law cases. And I brought with me 3 guests. Jeff Ray, who has been an attorney for over 40 years and is also a trained mediator. Jenna Ribbons, who is also a mediator, and she was a former assistant mediator for a local dispute resolution center. And Mieke Weissert, who has been an attorney for over 20 years, and she's trained in mediation and collaborative law. Thank you, all 3 of you, for joining us today.
Thanks for having us.
I wanted to start with you, Jeff, and Jenna. You created a brand new organization last year, Signature Solutions Group, and I would love for you to tell us what that business is all about.
Thank you, Lisa, for having us. Yes, Jen and I have known each other for a while. We got together talking about mediation, which is a passion of ours, and new ways we could communicate with people and involve more of the community, because there's a lot of conflict, not only in our profession, but elsewhere. So we have put together a group of mediators with a diverse background, 6 of us so far, and we're doing traditional mediation and domestic mediation for sure. I'm also a AAA arbitrator, so we offer that. In the last couple of weeks, we've added a limited scope representation attorney, which is something that is a nuanced thing that the Supreme Court is now allowing attorneys to temporarily get involved in cases in various aspects of those. So, yeah, we're diverse. We've branched out into the community, and we have a passion for conflict. As weird as that
Resolving conflict.
Resolving conflict.
So the thing that really struck me when I was talking with Jenna about this months ago was using the limited scope representation rule from the Supreme Court. And I don't want to get technical about it, but it's something that you applied to mediation that I had not heard anybody else doing. And so it was really a unique approach to helping people, especially with domestic relations cases, their family law cases, custody, parenting time, child support, whatever they have going on in their family, using limited scope representation mediators and attorneys representing them to help get their problems resolved, possibly without even ever having to go to court.
That's right.
Jenna, can you add a little bit onto that topic?
Yeah, we've been lucky enough to partner with a local attorney. She does family law, probate, all different kinds of law. But she is working with us to provide this sort of a la carte service to our clients that come in that may not be represented, but want to make sure the agreement that they've come to is legally sound and that their rights are being protected. So she's going to be able to provide those services at a much reduced cost. There's no traditional, you have to pay a retainer for her services. You pay for the services you're using and only the services you're using. So we're uniquely positioned to do that. And this has been around since 2018 in Michigan, and people aren't really
Underutilized, right?
Yeah, absolutely. So much so, our own courts put out videos about it, toolkits, all this information available to attorneys. So we took that information and all the stuff they gave us, and we're bringing it to our clients exclusively.
Now, Mieke, have you had a chance to do limited scope mediation?
I have not had anybody come in to do any type of limited scope yet, but perhaps working with Signature Solutions in the future, that might happen.
So normally when you go to mediation as an attorney representing a client, it's a client that you already have. You're in it for the whole case, basically, right?
That's correct.
Can you tell us a little bit about, just so the audience understands, like how does mediation work for the regular people who are fighting with the soon-to-be ex-spouse or maybe post-judgment custody or whatever the family law situation might be?
So mediation is a process where we have a third party neutral. And when I say neutral, they don't represent the other party. They don't represent the party that you're representing. They are trying to help the parties come to an agreement. It's a confidential process, which is very, very important. So nobody can call in a witness later on and say, this is what she said at mediation, and that's not fair. So keeping it confidential is very important because the parties can share more with each other. I like to prepare my clients for mediation very thoroughly. I like them to understand when there's a divorce, that they understand all of their assets and all of their debts and understand the process of mediation. And how the third party neutral is going to be helping them come to an agreement. So it's a very good process for family law. I use it regularly. I'm also a mediator, and I use mediation probably, I would say, for 98% of my cases.
So Mieke, in family law cases, there's often so many issues that have to be resolved. For example, in a divorce case, What if the parties agree on 2 or 3 of the issues that need to be resolved, but not the rest? What happens with the mediation then?
Oftentimes, the parties can agree to put together an order for those couple things that they've agreed upon. Sometimes the parties don't wish to do that because there's a very important issue that is outstanding and they don't want to agree on the others. So as long as the parties can agree with the help of the mediator, then that's how we go forward with that.
So I would like to know a little bit more about the process. Like, what's it like for the family members, the husband or wife, or whoever it is, the mom or dad, coming into your facility? Because you have an office in downtown Lansing that people can come to with multiple rooms. So more than one mediation can be happening at a time. Could one of you tell us a little bit about how it works at your office with the conduct of the mediation?
So our office is unique because we can offer online, Zoom mediations, have one person in the office, one person on Zoom, depending on the situation. But generally, we start out by speaking with each client, doing the intake process, which is when we also do our domestic violence screenings.
Which is required in family law cases.
It is.
Yeah.
It is in every single case. And all of our mediators are trained through the state court administrator's office the same way to do those domestic violence screenings. So we do those, again, like Mieke said, individually with each client, and it's all confidential. Sometimes their attorneys are there, sometimes they aren't, but it allows us to gauge what sort of domestic violence situation there may or may not be just by the answers to the questions that, we present to them. From there, we decide whether or not the parties can be together in the mediation, or if we need to do what they call shuttle mediation, going back and forth in different either virtual or physical spaces. We speak with the parties about their goals for the mediation, what they hope to accomplish and resolve, what issues they think they can resolve and work together to resolve. From there, we actually conduct the mediation. We have the neutral facilitator, either one of us or one of our mediators. They can select online. They can see the bios for each of our mediators and make the decision about the best fit. From there, the mediator will build an agenda based on their goals and the things they want to achieve, and will kind of guide them through the process, but keeping them in control of their own resolution.
Can it usually be done in one session, or is it a multi-session situation?
Sometimes it can be done in one session, depending on, the things that need to be resolved. Sometimes what we'll do is we'll agree to come back to mediation. Or in some parenting time disputes and cases, we'll say, hey, sometimes schedules that work when kids are a certain age don't work when they become older, or don't work if somebody moves or changes locations. So oftentimes they can come back for a check-in or to modify those agreements too.
So going back to the domestic violence screening, what happens if you see indicia that there's been domestic abuse or coercive control in the relationship? What path do you take in those situations?
Well, I know for us, safety is super, super important to us and something we're very vigilant about, and we need to be as mediators. Attorneys also can give us some insight into that as well, whether or not there's, no contact orders or there've been histories between these couples. But, that's when we decide, can they be in the same room? Is it safe for them to be in the same room? Do they feel like the other person can speak freely when the person that's been exerting that control and the gaslighting or whatever aspects of domestic violence may have been there? If we determine that they can't be in the same room, we do employ that shuttle mediation or that separate mediation when we need to.
Great. So if a person has a family law problem and they're talking to their attorney and they think they want to mediate, they can tell their attorney to contact Signature Solutions?
Absolutely.
Well, great. It was so good seeing all three of you today. Thank you for helping us understand the process, and congratulations
Thank you.
on your business that launched last year. I'm looking forward to working with you in the future.
Thanks
you,
for
Liisa.
having us.
In the Name of Family Law is brought to you by Speaker Law Firm. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Personal Injury Law.
When the weather is nice, there's no shortage of bicyclists on Michigan roadways. But we've also seen a rise in the past few years of accidents involving motor vehicles with bicyclists, and they often result in serious injury or death. Today we have Steve Sinas of the Sinas Dramis Law Firm to talk about the rights of bicyclists and bicyclist safety. Thank you for being here today, Steve.
Thank you very much for having me on.
So, Steve, just how many people in Michigan are getting seriously hurt or killed in bicycle accidents?
Well, just to give you an idea, between 2017 and 2022, over 7,000 people were injured in bike accidents and over 132 deaths.
And those were all involving motor vehicles?
Yes, yes. And when you're talking about bicycle accidents, certain cities, Detroit, Ann Arbor, Lansing, Kalamazoo, that's where many of these accidents are occurring. For the last 5 years, Detroit has had over 753 crashes, Ann Arbor over 244, Kalamazoo over 155, Lansing 154. So these happen too much.
So let's get down to basics. What are the legal requirements for drivers and bicyclists who are sharing the same roadway?
So in general, motorists are supposed to give bicyclists at least 3 feet when passing them. Bicyclists are also supposed to obey traffic laws and signal when they're turning. Bicyclists are not supposed to ride more than 2 to a side in most situations. They're supposed to yield to all pedestrians if ever using a sidewalk. So when you're talking about the legal rights of bicyclists, you have to look at, if they've been injured in a crash, you have to look at how the crash occurred, whether or not they were obeying the law, and also whether or not a motor vehicle or whoever else was involved was obeying the law.
So what are the most common causes of bicycle crashes with motor vehicles?
What we see mostly is situations where the people operating a motor vehicle just didn't see the bicyclist, or perhaps the bicyclist was totally visible, but in this day and age with such distracted driving that's out there, our bicyclists are just not seen by people who are operating motor vehicles because they're looking at their phone, they're looking elsewhere. So it's driver error. It's one common occurrence we see is when a bicyclist is going on the right side of a car and they turn right into the bicyclist, not seeing them. But plenty of just driver error, lack of observation on the part of the motor vehicle driver.
And what types of injuries do the bicyclists most frequently sustain?
It can vary, but because of the nature of the fact that the bicyclist is on a bike and there's no protection, we see spinal cord injuries, we see severe orthopedic injuries, and we see a lot of head injuries. The cases where the bicyclist has a helmet, they always fare better than if they didn't have a helmet on, but a lot of brain injuries.
And what damages can an injured bicyclist recover under Michigan law?
So when a bicyclist is injured in a crash involving a motor vehicle, which is not a motorcycle, it's like a car or a truck or a bus, they have a right to recover Michigan no-fault benefits. And that's very important to their care and recovery because, first of all, no-fault benefits cover the person's medical treatment. Depending on the amount of coverage available, it can be lifetime. It can be much more limited these days under the 2019 reforms, but there are important rights to recover medical expense coverage through no-fault insurance. They can also recover 3 years of income loss through no-fault insurance. So the first place to start is, do they have the right to no-fault benefits? If there is an at-fault party, they can also bring claims for damages against that at-fault party. If it's a motor vehicle driver, they can pursue their pain and suffering and excess income loss against that at-fault driver.
Does the injured bicyclist have to file a lawsuit against the at-fault driver in order to recover damages for their injuries?
No, we talk to a lot of bicyclists and they think that in order to pursue those damages, they actually have to go right into litigation. If the evidence can establish a claim clearly against an at-fault driver, oftentimes these claims can be resolved outside of a lawsuit with correspondence with the at-fault driver's insurance company. And so the first place we try to resolve cases is through the pre-suit negotiation process. If that doesn't lead to a resolution, then we can file the lawsuit and litigate the case at that point.
And how do insurance policies and the coverage that goes with them affect the litigation against an at-fault driver?
Well, so first of all, people should understand that if there's a lawsuit against a defendant, in almost all those cases, there's likely an insurance policy that covers that defendant. And that insurance policy has a limit of how much coverage there really is. Michigan law, the minimum is $50,000. So when you're hit by an at-fault driver, there's this big question, does that driver have the minimum of $50,000, or does the driver have $100,000 or $250,000 of damages? It can be $500,000, it can be $1 million. And so when we take in these cases, there's this big unknown, well, how much liability insurance is actually there with the at-fault driver. If there's not much liability insurance, the next question we ask is, does the bicyclist have uninsured or underinsured motorist coverage, which is coverage they buy themselves in the event that the at-fault driver doesn't have insurance, which would be an uninsured claim, or enough insurance, which would be an underinsured claim. And in that sense, their own insurance company stands in the shoes of the at-fault driver and pays the additional damages to our client. So you have to look at whether there's no-fault coverage, you have to look at the liability coverage, and then also inquire into this uninsured, underinsured motorist coverage.
So let's talk about putting your case together to make the strongest case for the bicyclist. What are the most important pieces of evidence that you have in a bicycle motor vehicle crash case?
Not to be too general or cliche, but all the evidence matters, especially in bicycle cases, because there's such an inquiry about who was doing what, who was looking where. There's this reasonable standard of care that applies in negligence cases, so you have to get all the evidence. And sometimes the police report isn't accurate, sometimes it's not complete, and there can be differing views from various witnesses about what happened. So you really have to look at all the evidence.
And what about the timeline for pursuing these types of cases? How much time does it take?
Well, you have to sue the at-fault driver, generally speaking, within 3 years from the date of the crash. You can try to resolve it with a pre-suit negotiation process with the parties involved. If that doesn't work, then you're filing the lawsuit, and that process can take a long time. The court gives you a scheduling order. You go through discovery. You don't have a trial date for probably up to a year or more from when you file the lawsuit. So that can be an extensive process, but a person's case can settle or resolve any time throughout that process. It doesn't have to be fully litigated to reach resolution.
So if a bicycle's injured in an accident with a motor vehicle, what steps can they do to protect their legal rights?
They're going to want to make sure that they have all the evidence and a clear understanding about what happened and what the police say what happened, what the witnesses say what happened, so they know how the accident is going to be characterized. Was it their fault, whether it was someone else's fault? So you want to make sure you look into that, and then you probably want to look into hiring an attorney. And I don't mean to say that in a self-serving way, but the reality is that the rights of a bicyclist are complex. There are nuances under the law. It's not intuitive. It takes a lot of analysis to figure out the full scope of someone's rights and also the full scope of insurance coverage that's out there. So you gather the evidence, you obviously pursue your medical care. That's really important to make sure you get the care you need. And then you consider what your legal rights are and whether you need representation.
Well, you talked about helmets earlier, really briefly. I know your firm has a special program where they help get helmets for kids. Can you just tell us about that really quickly?
We've given away thousands of helmets over the last 20 years. We're about to do it again this summer.
Awesome.
We believe in bike helmets. If you ride a bike, wear a bike helmet. Your brain is your most important asset you have. So wear a helmet, for God's sakes, please.
Thank you, Steve.
Thank you.
In the Name of Personal Injury Law is brought to you by the Sinas Dramis Law Firm.
Thank you for watching In the Name of the Law. We'll see you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.